My name is Christopher Smith. I'm the County Attorney for Cowley County, Kansas. We're here this morning for the release of the closing report of the County Attorney in reference to the officer-involved shooting of Tayler Rock. There is no doubt that on May 31st, 2014, Tayler Rock was operating a motor vehicle upon a highway of this state while his driving license privileges were suspended. This action, by law, is a misdemeanor crime and not a traffic infraction. The deputy saw Tayler Rock operating his vehicle. Thus, the crime was being committed in his presence, which allowed the officer to stop Tayler Rock and, if need be, to arrest Tayler Rock. The deputy lawfully stopped Tayler Rock. Once Tayler Rock stopped his vehicle, the deputy approached the vehicle and witnessed Tayler Rock leaning out of the driver's window with his upper torso and hands extended. The deputy noted that this was not normal behavior for a person who had been stopped by law enforcement. When the deputy arrived at the driver's door, Tayler Rock began demanding a reason for the stop and was verbally aggressive toward the deputy. A child in a forward-facing car seat on the rear passenger side was observed by the deputy. The deputy responded by introducing himself and told Tayler Rock that he had a suspended license and should not be driving. Tayler Rock was then told that he was under arrest. At that point, Tayler Rock became verbally abusive with the deputy, rolled his window up, and refused to submit to the lawful commands of the deputy. KSA 22-5229 prohibits any person from resisting a law enforcement officer making an arrest. The statute specifically states, a person is not authorized to use force to resist an arrest which such person knows is being made either by a law enforcement officer or by a private person summoned and directed by a law enforcement officer to make the arrest, even if the person arrested believes that the arrest is unlawful. Once Tayler Rock was told that he was under arrest, he had a legal duty to comply with the commands of the law enforcement officer. The deputy commanded Tayler Rock to roll the window down and open the door as he was under arrest. There was no response from Tayler Rock. The deputy again stated that Tayler Rock was under arrest and warned him that he would have to break the window and use force against Tayler Rock if he did not comply. The deputy stated, "Let's not make it go that way." Tayler Rock then rolled the window down about 4 to 6 inches and again became verbally abusive toward the deputy. The deputy was barely able to get his arm into the window and reached for the manual lock to unlock the door. As the deputy pulled up on the lock, Tayler Rock slapped the knob back down, relocking the door. The deputy again told Tayler Rock that he was under arrest and that he needed to stop resisting. The deputy was able to unlock the door and get it open on the second attempt. Once the deputy got the door open, he stepped into the doorway. Tayler Rock began kicking the deputy with his left foot while pushing and punching the deputy with his left hand. The deputy attempted to get a wrist lock on Tayler Rock's left wrist to pull him out of the car, but he was unable to do so. As the deputy tried to get Tayler Rock out of the vehicle, Tayler Rock lurched the car forward. The deputy warned Tayler Rock, saying, "Tayler, don't do this, you are going to get hurt." The deputy then removed his extendable baton, extended it, and warned Tayler Rock, "Tayler, stop now, quit resisting." The deputy attempted to make a strike, but since Tayler Rock was kicking him and noting the small space, he realized that he would be unable to make an effective strike. Again, attempting to gain compliance from Tayler Rock, the deputy entered the vehicle to try to get a force lock on Tayler Rock's arm with the baton. The deputy's intent was to gain control of the situation by using pain compliance and to get Tayler Rock out of the vehicle. KSA 21-5227 subsection A is the governing statute for a law enforcement officer's use of force in making an arrest. The statute states in relevant part, a law enforcement officer or any person whom such officer has summoned or directed to assist in making a lawful arrest need not retreat or desist from efforts to make a lawful arrest because of resistance or threatened resistance to the arrest. Such officer is justified to use the use of any force which such officer reasonably believes to be necessary to effect the arrest, and the use of any force which the officer reasonably believes to be necessary to defend the officer's self or another from bodily harm while making the arrest. Tayler Rock's refusal to comply with the deputy's lawful commands His verbal belligerence and his active physical resistance required the deputy to deploy physical force to gain compliance. The use of force was reasonable, necessary, and prudent given the situation at hand. Tayler Rock's refusal to comply with the deputy's lawful commands, his verbal belligerence, and his active physical resistance placed his child, himself, and the deputy in a situation where injury or death could occur. Traffic encounters between citizens and law enforcement officers are and remain one of the most dangerous interactions with the public for law enforcement personnel. According to the Federal Bureau of Investigation's Uniform Crime Reports, law enforcement officers killed and assaulted. Between 2003 and 2012, 96 officers across the nation were killed as a result of a traffic encounter. In 2012 alone, there were over 4,450 law enforcement officers in the United States who suffered serious bodily injury as a result of traffic encounters. In Arizona versus Johnson, the United States Supreme Court reiterated its long-held assertion concerning the dangerousness of traffic encounters by stating, quote, "Furthermore, the court has recognized that traffic stops are especially fraught with dangers to police officers," end quote. A driver's failure to comply with the lawful commands of a law enforcement officer, verbal aggression towards the officer, and physical resistance by the offender places the officer, offender, and passengers of the vehicle at risk for harm. The Kansas Supreme Court noted in State versus Rice that the United States Supreme Court has described police officer safety as a weighty interest, particularly during traffic stops, quoting Ohio versus Robinette. We independently observe, per the United States Supreme Court, the risk of harm to both the police and the occupants of a stopped vehicle is minimized if the officers routinely exercised unquestioned command of the situation. While the deputy was inside the vehicle with the baton against Tayler Rock grabbed the deputy's left wrist with his right hand and accelerated the vehicle. The deputy began to fall backwards but was unable to get free from Tayler Rock's grip. The deputy was face to face with Tayler Rock. He dropped his baton, he grabbed his handgun. He warned Tayler Rock, "Taylor, don't make me shoot you." Tayler Rock responded by rapidly accelerating his vehicle. As the deputy fell backwards, he reported that he knew he was going to die. The deputy stated that he had no doubt in his mind that Tayler Rock was going to kill him. Since Tayler Rock was not stopping, not listening, and had been resisted from the start, the deputy knew he had to fire his service weapon in order to save his life. The deputy fired into Tayler Rock and kept firing until Tayler Rock let go, and the deputy was able to break free of the vehicle. Again, KSA 215227A is the governing statute for a law enforcement officer's use of deadly force in making an arrest. The statute states in relevant part, however, such officer is justified in using deadly force only when such officer reasonably believes that such force is necessary to prevent death or great bodily harm to such officer or another person. It is disingenuous to argue that grabbing an officer's wrist, refusing to let go, accelerating a vehicle, and dragging an officer alongside that vehicle would not place an officer at risk of serious bodily harm or death. In fact, Kansas enacted a statute dealing with this very type of scenario. KSA 215413 subsection D3A codifies the crime of aggravated battery against a law enforcement officer by use of a motor vehicle. It states in relevant part, aggravated battery of a law enforcement officer is knowingly causing with a motor vehicle bodily harm to a uniform or properly identified state, county, or city law enforcement officer while the officer is engaged in the performance of the officer's duty. The deputy clearly stated that he knew he was going to die. The deputy clearly stated that he had no doubt in his mind that Tayler Rock was going to kill him. Since Tayler Rock was not stopping, was not listening, and was not obeying lawful commands, and had been resisted from the start, the deputy knew that he had to fire his service weapon in order to save his life. The sole issue before me is whether the deputy's use of deadly force against Tayler Rock was legally justified. The reasonableness inquiry in an excessive force case is an objective one. The question is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them. This reasonable officer standard was adopted by the state of Kansas in Lewis versus Marmon. The Kansas Appellate Court wrote, "Because of the nature of police work, the law does not require infallible judgment on the part of the police officer. He is not required to know with certainty that his life or another's life is threatened in order to justify his use of deadly force. All that is required is that the police officer's belief must be reasonable under the circumstances presented." This reasonable officer standard was again approved by the state of Kansas in Campbell versus City of Leavenworth, where the Kansas Appellate Court, after a review was denied by the Supreme Court of Kansas, stated, "An officer's actions must be determined in light of the facts and circumstances which led to those actions. We agree with the United States District Court for the District of Kansas that the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene, rather than with the 20/20 vision of hindsight. The calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation," quoting U.S. versus Holloway. Thus, the standard by which an officer's use of force is to be judged is one of a reasonable officer under the totality of the circumstances. There is also guidance from the Kansas Supreme Court in Doffenbach versus the City of Wichita. The court there stated, "A police officer is presumed to have acted properly until the presumption is overcome. There is general presumption that a public official will act fairly, reasonably, and impartially in the performance of the duties of his office. In this matter, it is undoubtedly clear that the deputy was placed in a situation whereby great bodily harm or death could be inflicted. It is without any serious question or doubt that a vehicle weighing more than 3,300 pounds was deliberately used as a deadly weapon against the deputy by Tayler Rock. The deputy clearly had a right to defend himself from perceived and ultimately actual harm. The actions of Tayler Rock on May 31st, 2014, when considered in totality, show that he placed himself and his minor child in danger of injury or death, and placed the deputy in the unenviable position of having to decide whether or not to use deadly force to keep him from serious injury or death. Thus, the decision by the deputy to use deadly force was reasonable under these circumstances. While the events of May 31st, 2014, which resulted in the death of Tayler Rock, were tragic and will affect the lives of many people, it is determined that the actions of the Cowley County Sheriff's deputy were justified. I so find. There are copies of the report for anyone wishing to have them. They are up here at the table. Thank you very much.